Fadan, I'm a family law solicitor practicing in Sydney, Australia, and this is a case note, the case of Daultrey and Tavener. This is a de facto relationship between Steve and Kate. They were in a relationship for 6 years off and on, so cumulatively 6 years when you add up all the periods they were together and separated. Now, these people had been fighting for 5 years, that is, litigating for 5 years, and the decisions only just came out last month, the final decision. So let's get into it. Now, these parties were in a relationship from 2009 to 2014, off again, on again. And they both had children from other relationships. And for periods of time, he moved into Kate's house and lived there for periods of time and then would move out because their kids didn't really get on. She had substantial assets at the start. So Kate was wealthy at the beginning of the relationship. He had some assets, but hardly anything because it was heavily in debt. The judge found at the trial that Kate had substantial wealth at the start and she had significant initial contributions to the relationship. Now, after the relationship ends, then Steve makes a claim on Kate's assets. And as I say, they're fighting backwards and forwards. Early on in the proceedings, Kate agrees to give Steve a sum of $200,000. That $200,000 was classified as partial property settlement, meaning it's an upfront payment of money that was coming to him anyway. So it would be taken into account in the final decision. So she gave him $200,000. So he already had that $200,000 as well as superannuation and other bits and pieces. So it comes before the trial judge in 2023, the final hearing. The trial judge hears all the evidence. Steve was asking the court to make an order that Kate pay him $568,950, right? That was his claim. And Kate was saying, I don't want to give you anything. I don't think I have to give you anything. I already gave you the $200 and you've spent it. But that $200,000 was partial property settlement, so you've already got it, and I think the court should do nothing. We should each walk away with what we have. The trial judge listened to all the evidence, and he had found that Steve didn't make a full disclosure of his assets. That was in the judgment. Here we go. I take into account that there has not been a full and frank disclosure on the husband's part, even though the de facto he called him the husband. It's a family law thing. And that matter is significant given that during the relationship, the husband received about $1.5 million from the sale of his interest. So he had money and it all kind of disappeared conveniently by the time of the trial. So the judge took that into account. Now, how big was the asset pool at the date of the trial? It was $1.7 million. Now, that's what they had cumulatively together. His and hers combined was 1.7. Kate was already sitting on 62.5% of the assets and he was sitting on 37.4. So if the court did nothing, that was the outcome. So the learned judge, Judge Tonkin, considered all the evidence and said the first step for the court to do in any family law settlement is to consider whether anything needs to happen. And that's the High Court Authority of Stanford. He reviewed all the evidence and said, I think that the case of Stanford, which is a High Court Authority, applies. And that is that there should just be a walk away. The husband has already received $200,000 and the $200,000 he's received I must take into account. Had he not have received that money, the result may have been different. But because he got the $200,000, I think that everything should just stay where it is and he should not get any further adjustment. The wife should just keep her assets, the husband should keep his assets, and they should just, go off into the sunset and live their lives. That was the decision as at November 2023. So basically he said, Steve, fuck off, you get nothing else, you got your $200,000, be happy with it and shut up. So that was the initial judge's decision, Judge Tonkin. Now, Steve said, I don't like that decision. I don't think that's fair. What about the $568,000 that I was after? So he says, excuse me, Judge, I don't like that decision. I'm going to appeal. So he appeals to a Division 1 judge, so it's not the full court or the family court, it's just a Division 1 judge who's a more senior judge, and it comes before Justice Campton. Now, Justice Campton reviews all the evidence, and he appealed on the grounds that the court didn't take into account all my contributions and other things. And the learned judge said, well, he didn't have to do that because he used the High Court Authority of Stanford. The first step is, should the court do anything? Having a look at where everything lies and the history of the matter. He already got his $200,000. You don't get any more. The wife was entitled to pursue, because her case was he doesn't get anything else. That was her argument. The court accepted that argument. It was within the judge's discretion. So guess what, Steve? Fuck off. You get nothing else. Don't be a greedy asshole. He'd been fighting this case for 5 years, trying to get more money out of poor Kate. He got the $200,000, which frankly, I'm not entirely sure how he managed to do that. Her lawyers could have run an argument that he doesn't get anything and maybe she didn't have to pay him the $200,000. But anyway, she did. He got to keep it. That's the end of the case. It was a good decision in my view. Fuck off, Steve. One other thing. So not only did Steve lose his claim, lose his appeal, he also had a costs order against him because he was wholly unsuccessful in the appeal. So Justice Campton ordered that he pay Kate's cost fix in the sum of, I think it was $12,000. Here we go. Here's a copy of what orders were made by Justice Campton on the 22nd of April 2024. The notice of appeal is dismissed. That means he lost. And order 2, the appellant, that's Steve, pay Kate her costs fixed at $15,000 within 28 days. Yeah, suck it, Steve.